All right, so we've got the latest in litigation of the gun and magazine ban here in Illinois, all stemming from the law that Governor J.B. Pritzker enacted January 10th. And ultimately, you have a hearing that's set in the 7th Circuit Court of Appeals, June 29th. But a little twist and turn here in the Southern District, where you had 4 plaintiffs groups actually secure a preliminary injunction against the gun and magazine ban. And that was then stayed by the 7th Circuit Court of Appeals, and now the 7th Circuit has all these cases. But Thomas Magg, who's the attorney who filed a lawsuit out of Crawford County, he was the first to file that lawsuit challenging it on Second Amendment grounds, says it violates the right to keep and bear arms, but also on Fifth Amendment grounds and 14th Amendment grounds. The Fifth Amendment grounds of not having somebody required to incriminate themselves, that has been kind of put off to the side for possible future debate in court. But the Madison St. Clair Record, their reporting here has indication of a little bit of a twist and turn when it comes to the filings that Magg had recently put in. So Magg filed a motion for a partial summary judgment. And this, again, is after you had a preliminary injunction issued, and that injunction was stayed by the 7th Circuit Court of Appeals. But Stephen McGlynn, the federal judge in the Southern District, is being asked by Magg to issue a partial summary judgment on this case. He says this court previously heard motions for preliminary injunction as the Second Amendment claims is in this case, specifically reversing the remaining claims in the case for future ruling. One of those reversed claims was the vagueness claim. Granted, the preliminary injunction issues is presently presiding in a higher court, which appears headed to fast train to Washington, D.C. However, this case is not stayed. The time to hear the claims is now, Magg argued, saying that the statute is void for vagueness. But earlier this month, you had the Illinois State Police, through their attorney, essentially ask Stephen McGlynn to not accept this motion for partial summary judgment. The attorney saying, in the interest of judicial economy and to avoid piecemeal litigation and appeals, the court should continue its stay on the proceedings on these claims and deny without prejudice the Langley plaintiff's summary judgment motion, the attorneys say. They go on to say that partial summary judgment was considered now and any ruling would be immediately appealable. Given that briefing and argument will conclude in the 7th Circuit regarding the current interlocutory appeals before briefing of this instant motion, deciding the Langley plaintiff's motion would generate a second interlocutory appeal too late for consolidation with the currently pending interlocutory appeals. So, again, the back and forth here continues, even back in the Southern District of Illinois, where you had Stephen McGlynn initially issue that preliminary injunction back in, was it April, where you had 6 days of a window of the law not being enforceable statewide, and then you had the states go to the 7th Circuit Court of Appeals and secured a stay, essentially reversing McGlynn's preliminary injunction. But Magg, he wants to get back into the Southern District and have McGlynn issue a partial judgment against the gun and magazine ban. So what does that mean for what's happening in the 7th Circuit? Obviously, they're separate courts. The 7th Circuit's the higher court. The Southern District is the lower court. And then all of this being consolidated in the 7th Circuit, possibly going to the U.S. Supreme Court, depending on how the outcome of the June 29th hearing is in federal courts. So interesting to see this little twist and turn in the Southern District. Figured I'd get that out for you as it was reported by the Madison St. Clair Record. And if you want to read that in its entirety, you can find that on their website at madisonrecord.com. So be sure to check that out. In the headline, Magg seeks partial summary judgment in gun ban challenge. Illinois State Police Director asks for a stay. So it's going to be an interesting couple of weeks here as we've got even more filings expected. The plaintiffs are going to file in the 7th Circuit Court of Appeals later this month. Then you'll have reply briefs. And then June 29th, the case will be heard in Chicago about Illinois' gun and magazine ban. Coming back, we'll talk about a measure that passed the statehouse that deals with first-time nonviolent gun offenders and a diversionary program that's been in place since 2017 but was set to sunset. Well, they're looking to lift that sunset, lower the age of who can participate in it. But an interesting motive that a Republican state senator postulates on the Senate floor. We'll hear that debate on this measure that could be headed to the governor's desk any time now. So stay tuned for that. We'll get to that next here on WMAY.
Inclined to participate in this because of the recent gun bill, where you've got a lot of law-abiding gun owners that are going to potentially face criminal penalties. I suspect that has nothing to do with any data as far as whether or not this has been successful, because you said police have changed their minds about this program. What data can you point to that caused police to change their minds about this program? That's
State Senator Steve McClure from Springfield, a Republican, during Senate debates before they adjourned back in last month, and talking about a bill that would allow for a program to essentially defer charges against somebody, or at least deflect them from going to prison for first-time nonviolent gun offenses in exchange for going on probation. And that's a bill that was advanced out of the Senate. It advanced out of the House, has bipartisan support, could be sent to the governor's desk here anytime. And it's something that was part of House Bill 676. If you recall, we talked about House Bill 676. It was an omnibus package that at one point said that you couldn't discharge a firearm 1,000 feet from, or 1,000 yards rather, from a residential line. Right now it's about 300 yards from a residential line. That element was removed from 676 before it passed the House. But the measure also included, changing the red flag laws, also dealing with creating a task force to look at insurance mandates for gun owners. But it also included changing this first-time offender program, this first-time nonviolent offender program. House Bill 676 passed the House as an omnibus, did not advance in the Senate. However, the standalone first-time offender expansion, that did advance, again, standalone on its own separate bill, out of the Senate and then out of the House. So it's queued up for the governor. Here's the debate between State Senator Ron Villavallum, he's the Democrat from Chicago that advanced this bill, and State Senator Steve McClure from the Senate before they adjourned last month. Here's how that debate went about the bill, about the data to show whether or not the program that's been in place since 2017 is successful. McClure suspecting there might be some other motivations behind this bill, but ultimately it passed with bipartisan support. Here's that debate.
As amended, Senate Bill 424 removes the sunset to a diversion program for first-time nonviolent gun possessions. This legislation has no opposition. It has a broad spectrum of support from gun violence prevention groups, criminal justice reform groups, the Illinois State's Attorneys Association, the Illinois Association of Police Chiefs. I would ask for an aye vote and happy to answer any questions.
This program, my recollection was that you said it took effect in 2017. So what is the recidivism rate for those that have participated in this program?
So first, let me note that there's efforts to collect more data on this. That being said, the information that I've been provided, according to a 2021 study by Loyola University of Chicago's Center for Criminal Justice Research, Policy and Practice, 93% of individuals convicted of firearm possession did not go on to commit violent offenses through this program.
Okay, so you've told us that those people that are not using this program, the people that go through the regular process and actually face real penalties, they tend to not reoffend. However, the people that we're giving these chances to, we don't know if they're reoffending or not. That's concerning to me, but I'll move on since we don't have that data. You said the program is successful. By what are you measuring the success of the program? Because you don't seem to have data on anything.
Senator Villavallum.
Senator, I'm measuring success of the program based on the fact that this program has been in place for 5 years. It is completely an opt-in program. We have 13 counties that have opted in. The state's attorney has to initiate this. The chief judge has to agree. And oh, by the way, there is a broad coalition of organizations from gun violence prevention groups to criminal justice reform groups to the Illinois State Rifle Association, to the Illinois States Attorneys Association, and the Illinois Association of Police Chiefs. Law enforcement originally was opposed to this program, and now they are a proponent. So that's how I'm measuring success.
I suspect that people are more inclined to participate in this because of the recent gun bill, where you've got a lot of law-abiding gun owners that are going to potentially face criminal penalties. I suspect that has nothing to do with any data as far as whether or not this has been successful, because you said police have changed their minds about this program. What data can you point to that caused police to change their minds about this program? So this program began in 2017, and this was for people that were under the age of 21. How has gun violence been since 2017? Is everyone happy with the way things have been? Wouldn't it make sense to study the program and have the numbers here to talk about success? Wouldn't that make sense, like in any other field? Can you imagine going into the office and say, well, I have no clue how this program's been working, but gun violence is really bad, but let's just give people that are caught with guns a break. And we've seen that over the summer. We saw a young man who was caught by police. Cook County decided not to charge him, gave him a break. And at the age of 18 years old, he murdered a police officer. How many cases do you think that we're going to get over the next few years where someone participating in this program and killed somebody? The question is not whether it's going to happen. The question is, how many cases is this going to happen? And the senator was talking about the bill. He doesn't have the results from this program, but he says people that actually went through the regular way and received probation or received a prison sentence, something like 96% of them don't reoffend. If there's a program that's working, it seems to be that program. Why aren't we continuing with that?
So State Senator Steve McClure there with substantial questions about this. He was one of the no votes, but there were bipartisan votes on this bill that did advance both chambers to lift the sunset of the first-time nonviolent gun offender diversion program, and now it's going to be heading to the governor's desk. But interesting, he notes there, again, as the gun ban is being challenged in the 7th Circuit Court of Appeals and apparently back down in the Southern District Federal Court, you've got this program that could include people who are wrapped up facing fines if the gun ban is upheld, and not just facing fines, but also facing felonies. So, these would be nonviolent offenses, I would imagine, for the most part. So kind of fascinating to hear that debate in the overall context of the questions about Illinois' gun and magazine ban. Much more to come on all of that as we continue to track what happens here in Illinois concerning the Second Amendment. And don't forget about that story that's really blown up my Twitter about the governor saying that if you want to challenge laws in state court, you can only do it in Cook and Sangamon counties, which has a lot of people online pointing out that to them this seems like tyranny, and also looks like the Democrat majority, according to comments online, are gearing up to pass even more controversial legislation down the pike, and possibly blocking people from being able to sue in their backyard. They'd have to travel hundreds of miles to sue in either Sangamon or Cook counties. All right, it is Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and